Yes, Mr.
Come on, we were on the Teare,
Yes.
and that's Authorities Bundle again, tab 2, Authorities Bundle 2, tab 27. And I had just taken your lordships to what the arguments were. Can I just take you through now what was decided and why? We can essentially start at 98, and that's on page 549. And again, I'm going to come back to this in about 10 minutes on some separate submissions, but passage planning is not a science. It inevitably is an element of judgment as to what annotations need to be made on the chart. And then what happens, my lord, is at paragraph 99 to 100, the judge finds that actually the pilot's passage plan was not defective. So there's a decision that it's not defective. But then he says at 100, but let me assume in the claimant's favour that the passage plan was defective in one or more of the respects suggested. And here I accept he's talking about the pilot's passage plan. It was not in any event contended that this flowed from any failure of the defendants to provide proper systems in the sense that the guidance and the instructions furnished by the owners were in any sense inappropriate. Section 5 of the Navigation Procedures Manual was devoted to passage planning, including the requirement that planning should include any passage through the pilot's quarters. Those instructions, taken with the additional publications furnished on board as such as the Bridge Procedures Guide, were agreed to be fully appropriate and sufficient. And the same in this case, and we'll come to that later, that my learned friend's expert agreed ours were. He says, against this background, the focus of the claimant's attack became the newly pleaded allegation in relation to the competence of the master. And then he goes on and looks at the competence of the master, and he holds that the master was not incompetent. Now, what we say is paragraphs 100 and 101 are important. In paragraph 101, the judge says, against this background, the focus of the attack became the newly pleaded allegation of incompetence and his flawed attitude towards passage planning. This background, my lords, is the background in paragraph 100. And what we say, in particular, the agreement between the experts that the owner's systems, guidance and instructions were fully appropriate and significant. Now, a number of points arise from this. First, the pleaded case in this judgment, paragraph 30, that a one-off passage plan rendered the vessel unseaworthy. Given that pleaded case, paragraph 100 can only have been addressing that case, because it's not addressing the case of incompetence. That's being addressed in paragraphs 101 onwards. So this paragraph can only be addressing the plea in paragraph 30 of the judgment, where he sets out the particulars that a one-off defective passage plan can render the vessel unseaworthy. Because there's only two pleas in relation to passage planning. It's one-off defect and or incompetence. So, second, the judge found that the passage plan was not defective, but said in any event, even if it were, the vessel would not be unseaworthy. So I accept its obiter.
It's all obiter, isn't it?
I accept its obiter. I accept that. Thirdly,
I thought you said that the pleaded case at paragraph 30 was superseded by a case essentially of incompetence, flawed attitude.
No, it's not superseded. It was. They
You certainly said superseded, because I wrote it down and wouldn't have made it up.
Should have been.
Then that's my error, gentlemen. I apologise. I don't know if I obviously must have used the word superseded. I didn't mean to. What it is developed. What they did was they ran, just like in this case. In this case, it was originally, well, in fact, it's the opposite of this case. But in that case, it was originally one-off defective passage plan, the paragraph 30 point, and then the paragraph 39 point. They also then amended the pleadings and also ran incompetence of the master.
But the reality is that Mr. Russell's pure point on 3.1 was not pursued.
No, it was pursued. What happened was, and that's the paragraph 101, against this background, the focus of the claimants' attack became the newly pleaded allegation. The background is, because they couldn't win on a one-off defective passage plan, because by the time it got to trial, and basically by the time the experts were cross-examined, and Mr. Brenton's expert had conceded that there was nothing wrong with the systems on board the vessel, it then moved to incompetence of...
So Mr. Brenton didn't take this particular point, he took another point.
No, I don't think that's right. What happened was the pleaded case
You
was...
don't submit that's right.
I don't submit that's right, my lord. I think the pleaded case, my lord, was one-off defective passage plan. But the judge goes on to decide it in paragraph 100, and this is my point. He decides it in paragraph 100 by saying that the vessel was not unseaworthy, because essentially what he's saying is a one-off defective passage plan does not render the vessel unseaworthy, and because the systems and guidance and instructions which the owners had put in place were fully appropriate. In other words, the vessel would only be unseaworthy if there were inadequate systems to instruct the crew to conduct passage planning.
Well, you can see you can see exactly what the case was that the judge was addressing in paragraph 96, can't you? Where he summarises it. This is obviously summarising submission made by Mr. Brenton. There was no proper top of page 549, left-hand column. No proper passage plan in place to assist the officer of the watch or to encourage him actively to monitor the progress of the vessel. Claimants contend this was because the master possessed a flawed attitude towards passage planning in general and passage planning whilst under pilotage in particular. So the focus there appears to have been on a criticism of the way in which the master approached pilotage whilst under, passage planning whilst under pilotage, in reliance on pilots and pilots' charts.
Well, my lord, that would be right, but for paragraph
Because it's not. I mean, going back to the criticism that was originally made, which you showed us in 59.
Yeah, and paragraph 30 was the pleading, yeah.
The actual passage plan by the ship for the pilotage bit of it was pretty ambiguous, wasn't it? Or pretty well non-existent, actually.
My lord, it was, but then they also, my lord, in paragraph 98 and 99, he goes on and considers the criticisms of the pilot's chart. Paragraphs 99 onwards are the three criticisms of the pilot's passage plan. The pilot's. And what happens, my lords, is, and this is my submission, he says the pilot's passage plans are not defective. Paragraph 100, but let me assume in the claimant's favour that they were defective. He then says in any event the systems were adequate. Therefore, he says against that background the focus changed onto incompetence. And I take it no further than that to say what I say the judge is doing in that case is he's saying I'm dealing with the pleaded case. The pleaded case is one-off defective passage plan. No, because the systems were adequate, and therefore I'm now going to go on and deal with the other way in which they put their case, which is incompetence. Otherwise you didn't need a paragraph 100. Paragraph 100 doesn't go anywhere. It's not relevant to incompetence of the crew. It's only relevant to the fact that he's prepared to assume that the passage plan was defective. And why is it relevant there? It can only go to two questions. It can either go to the vessel was not unseaworthy because all the owners had put in place all of the correct instructions and procedures to tell the crew what they should be doing, so it's not unseaworthy, which is the first way I put the appeal. Alternatively, he's considering with the second level, he's saying, well, even if a one-off defective passage plan makes the vessel unseaworthy, owners didn't fail to exercise due diligence because they put in place all the correct procedures and instructions to the crew.
So I'm afraid you've succeeded in confusing at least me, Mr. Hill. I had thought that your case was, certainly it appears to be in your case in front of Mr. Justice Teare, that Mr. Brenton in the Teare had not run a case of what you call standalone unseaworthiness, but now you seem to be telling us that he did.
No, my lord, I don't think that's correct. What I said was very clearly is that Mr. Brenton, in the light of the evidence at trial, refocused it. As it says in 101. I don't need to really paraphrase. It's what he said in the introductory words of 101. But my point is, in paragraph 100, he is actually dealing with the original pleaded case, because it makes no sense otherwise. Very quickly, my lords, there's also the Jai High case, which you will see, my lords, which I accept doesn't take the matter too much further.
Where do we find that?
You'll find that case, sorry, my lord, tab 36. This is the only other case either side could find in relation to passage planning. It's a decision of Mr. Justice Rob Knowles. And essentially, my lord, and let me say this straight up front, it appears that it was not pleaded that a one-off defective passage plan can render the vessel unseaworthy. We rely on it essentially for this being an example, a further example, that certainly in the industry people did not perceive a one-off defective passage plan itself rendering the vessel unseaworthy, and the focus is on instead the ship owner having to put in place appropriate systems to ensure passage planning is done correctly. And in this case, what happens is that they lost on a summary judgment application. So the test was, there really had been no evidence to support the suggestion that the owner's systems in place were not adequate. And that comes out on page 397 by the red marking, and also on 398. But again, this isn't going to hold your lordships up, as it were, if you're not with me on the principle.
No disrespect to the learned judge, but it's pretty exiguous, really.
It's not going to hold it if your lordship's not with me.
I don't think we're going to be.
So what proposition do you rely on that this case you say supports?
What it doesn't deal with as opposed to what it does. Is that the point?
Yes. Essentially, it's the only other.
I don't think, to be honest,
well, your lordship,
the fact that it wasn't argued, and the fact that the judge in a summary judgment application in 3-page judgment doesn't deal with a point that wasn't argued before him doesn't really seem to help.
I'm not, my lord. I'm not overplaying my hand. I'm just simply saying this is the only other case we could find in the authorities or any judge considering passage planning. Okay. That's all we rely on it for. My lord, so I've made my next point on my roadmap. There's no other cases on passage planning. My lord, have my point in the skeleton, which I won't repeat, which is that the judge below considered that it was significant that the new guidelines had come out in 1999, and we say there's no significance to that at all, and you will have seen from my supplementary skeleton and also the documents we put in the supplementary authorities bundle, passage planning has been a very well-known concept back since the 1970s, 1973. In the 1980 document itself says passage planning is not a new concept. Good ship owners have been doing it for a long time. So there's nothing new in this passage planning idea. So again, it's a small point, which is if a passage plan does render a vessel unseaworthy, you would have thought somebody would have taken this point at some time in the last 50 years, and it hasn't. And every time somebody does take this point, the Teare or Hague Rules, it's done in the concept of the way I've put it to your lordships, which is the onus is on the owner to put in place all the systems to ensure that, and all the materials and all the competent crews, so that passage planning can be done properly. But the actual act of passage planning is a navigational act which is not within that provision. My lords, equivalence with charts, I want to briefly deal with that. The judge, in paragraph 79 of his judgment, makes much of there being an equivalence with charts. We say there's no such equivalence, my lord. A chart is not the product of any navigational decision. That's the first point. In contrast, a passage plan is created by the ship as part of navigation, whereas a chart is part of the equipment that the ship uses to conduct navigation. It really goes back to this distinction between an owner providing all materials on board the vessel and giving appropriate instructions so that the vessel can be navigated safely, as compared with the subsequent use of materials by the crew to navigate safely.
Isn't a passage plan something that the ship uses to conduct navigation? That's what it's for, isn't it?
It is correct that when at sea, the crew will use the passage plan to navigate. I agree. But it is a product itself of navigational decisions that are all part of passage planning. My Lord, if I can put it this way, if you think about the IMO passage planning guidelines in 1999, there are 4 stages: appraisal, planning, execution and monitoring. A passage plan covers all 4 stages. I accept that completely. And what I do say is there is no temporal difference, which is what the judge held, between acts in preparation of navigation and navigation, because that is going back to the discarded rule in the SS Lord, which Lord Hobhouse rejected, which is that there is somehow this temporal distinction. As Lord Hobhouse says in the Hill Harmony, before you leave berth, laying it off on the chart and deciding how much distance to give to a hazard and the like are all navigational decisions, acts. And it would be essentially, if one takes if you look at it as if you take the preparation for navigation as opposed to navigation distinction, you are cutting the IMO guidelines in half and saying appraisal and planning is all seaworthiness and pre-leaving the berth, and execution and monitoring is all navigation after you've left the berth. And that is wrong, as is very clear from Lord Hobhouse's decision in the House of Lords.
Well, I know you've got the 4 stages in the guidelines, but to say that execution or monitoring are part of planning is not really a natural use of language, is it?
That's an interesting point. Passage planning is, as seafarers see it, a 4-stage process, because you can't stop just because you've written it down in a document. You've got to constantly review it, and situations change when you're at sea. You've got to monitor your progress, see whether you're actually maintaining the plan. This is all part of the planning your passage and how to conduct the passage.
But Mr. Hill, if you look at the language of the IMO guidance itself, which you'll find in tab 2 of the supplementary bundle,
Yep.
as my Lord says, page 34,
Yes.
under the heading execution. Having finalised the voyage or passage plan, it should then be executed. So it's making a clear distinction. You keep saying that there are 4 stages to planning, to a passage plan, but with respect, as made clear here from the guidance, stages 1 and 2, appraisal and doing that planning, are one part of it. And then you get going in the ship and execute it. And we're talking about a defective passage plan.
Stage 2.
See paragraph 4.1. Having, past tense, finalised the passage plan, you then execute it.
My Lords, I don't disagree with any of that. I agree that there are 4 stages, and 2 stages, the latter 2 stages, proceed on the basis of stage 2 has taken place. That's not my point. My point is, I say that's not legally relevant. My point is, all 4 stages are the act of passage planning. The document's headed Guidance for Voyage Planning. Just as just as, for example, my lords, if you lay off a route on a chart before you leave the berth, that is planning. It tells you what route you're going to take. And if you do that negligently and you go over an area of water you shouldn't, that doesn't mean that that's not a navigational error. It is. It's all part and parcel of navigating the vessel.
There's also a clear temporal point in the preceding paragraph 3.4. You have to have a passage plan with all its details approved by the master prior to commencement of the voyage.
I agree. I don't dispute any of that. I say my arguments aren't undermined by that because it goes back to this discredited and rejected suggestion in the Hill Harmony that the character of the act somehow changes because it was where it was done or when it was done. The crew are tasked with the job of navigating. As part of navigating, they do stages 1, 2, 3, 4. And the fact that you have to have stage 2 done before you do stages 3 and 4, I say, doesn't undermine my argument that stages 1 and 2 are still navigating, even though they take place alongside the berth on the 17th of May before you leave on the 18th of May. They are still acts of navigation, and they are still errors of navigation. And I go back to my point. There's no real difference between a second officer when he's on watch misreading his own chart and passage plan compared to the second officer when he's alongside the berth writing that passage plan erroneously in the first place. But where's the difference, we ask rhetorically? My lords, that deals with, I think, yes, I just need to say on equivalence of charts. Well, actually, I'll do this later when I come to the respondent's notice. It's all about a mechanical exercise, but I'll deal with that on the respondent's notice. Can I now go back to section 3 of my roadmap, which I didn't do initially because I wanted to get out of the way the authorities. Now go back to an important part, which is the character of passage planning, because I feel this is what your lordships are slightly concerned about. And I think I need to just make some submissions in relation to what is passage planning and why it cannot be an attribute of the vessel. Firstly, I want to make some submissions about passage planning versus passage plans. Passage planning is a process undertaken by the master and navigating officer to plan the passage and then implement it. And if necessary, he has to amend the plan, and that's clear from the IMO guidelines themselves, which those behind me have just asked me to stress. And, my lords, what we say is that the passage plan is contained in many documents. This will include, at the very least, the working charts, more than one. All the working charts that were needed to get you to Hong Kong, for example. It will include a voyage plan book or document. It will include a number of other documents like tide tables and nautical publications. Our passage plan had attached to them at the back the tide tables, or a page of the tide tables showing what the tides would be. It also has the underkeel clearance calculations. Now,
why do things like the UKC and tide tables and why do the number of documents matter?
Yes, because it's not as if in lots of seaworthiness cases you just look at a certificate. Do you have a deraterization certificate? Do you have a fumigation certificate? Do you have something that you can just look at and say yes, you comply or don't comply? This isn't that sort of point. It's not just the vessel having a documentary certificate. Your lordship put to me earlier, before the shorter German, well, come on, Mr. Passage planning is all about, these days, having the document to follow. Well, the document is and I'm going to come on to this now, is a document that is carefully drawn up using seamanship and judgment, and it's a complicated document.
So what?
So
You
what?
have a package of documents, but so what? What's the legal point to making?
Well, the legal point, that it is a product of, critically, is a product of seamanship and navigational skill, which are exercised by the navigating officers in their capacity as navigators. And this is not an attribute of the ship, it is an act of seamanship and judgment by the navigators. So, first you get that from the guidelines themselves. I know you've looked at the guidelines, I won't therefore take you through them. The guidelines make it clear that it's all an issue of judgment and seamanship and skill. And the M notice right back from 1978 talks about making a balanced judgment in relation to margins of safety and the like. Mr. Justice David Steele in Teare rightly said that it's not a science and it involves judgment. It's not an art. Next point, my lords, if you can just turn up the judgment itself in tab 7 of the core bundle. This passage plan was principally dealt with, and I'm going to just show you the areas where it is. It starts on page 82 of the bundle in paragraph 24, goes up to paragraph 54. All of that is discussing this passage plan. Then it goes 59 to 73 as well. And then I've asked you already, my lords, to look at paragraphs 67, 68 and 69 on page 91, where his lordship goes through a careful analysis of the different expert evidence as to what you should do, whether you should patch it, whether it makes it too busy, whether you should put a warning. And having in paragraph 70, he rejects the suggestion that you could just keep the notice to mariners on one side and refer to it when you want. And he preferred the idea that you would write it at the top of the passage plan. This is all areas of these 10 pages of the judgment demonstrate the nature of passage planning as a matter of seamanship and navigation, involving significant nuances and judgment on the part of the officers involved in navigation. It also emphasises the corresponding time and effort which needs to be investigated in order to examine and conclude whether a decision within the range of good seamanship or whether it falls outside that range.
Well, I'm not so sure about that. I mean, at the end of paragraph 70, the judge's conclusion, having considered the expert evidence, whilst it would be, of course, prudent to note the warning in the passage plan, it would also be necessary and prudent to mark the warning on the chart, since that is the primary document to which the officer navigating would refer. So the judge found that the defect was failing to note the warning about the shallow depths on the chart.
Correct. But that is, there was, and our master mariner didn't think that was necessary.
Well, the judge preferred the other side.
He did, my lords, but what I'm trying to say is, this is an art, not a science. Navigation is an art, it's an art, not a science. These are judgment calls being made by navigating officers, qua navigators.
And findings of fact may be an art, not a science, but you're stuck with the findings of fact of the judge on the expert evidence.
And I'm not going behind that at all. What I'm trying to say is, the judge was quite entitled to say this passage plan was defective. It's the next step to say that therefore rendered the vessel unseaworthy, which is a legal analysis. I'm not going behind his findings of fact, and I accept them.
But every act on board the vessel at the load port, which is something other than sort of mechanically writing something down, involves an exercise of judgment by those on board the ship. But at the end of the day, a judge who's having to decide whether or not that renders the ship unseaworthy reaches a conclusion of fact as to whether that judgment was a defective judgment and therefore the ship was unseaworthy, and that's what this judge has done here. He said, well, never mind the fact that it could have been done in other ways. My finding is that it should have been done in this way, and it wasn't.
And the answer to that...
So resorting to saying, well, it's all an exercise of judgment doesn't help, does it?
No, well, it does, because what I'm saying is that the carrier's obligation under Article 3, Rule 1, the carrier's obligation is to make the vessel seaworthy, and it's qua carrier in his capacity as the carrier, the ship owner. It's not within his orbit of responsibility to navigate.
Well, you're going to have to show us the authority you rely upon to support that.
I will do. Just before I do so, my lords, just on the point that your lordships have just made, my lords, my learned friends in paragraph 60 of their original skeleton, they say, well, there are many documents and many judgment calls that are made, and they say, these have all been held to render the vessel unseaworthy. But actually, there's a fallacy in the way in which they put that. For example, the vessel is unseaworthy because she's unstable and her cargo is improperly lashed, not because of any inadequate stowage plan or lashing plan. It's the consequences of it. Likewise, a vessel would be unseaworthy because she has insufficient ballast, not because her ballast plan is deficient. And the point I'm trying to make here, I'll do another one. The vessel is unseaworthy because she has insufficient bunkers on board.
Well, I mean, this all goes back to your point about physical attributes or attributes of the vessel.
Well,
with respect, because the point that will be made is, well, yes, it is true that if you have an inadequate stowage plan, that may lead to instability of the vessel. But what's said here is, if you've got an inadequate passage plan, that may lead to the vessel grounding.
But no one's jumping there, because the defect is the inadequate stowage.
You might be lucky on the particular voyage.
Well, no,
notwithstanding you've made the ship unstable because the sea is very calm, she manages to get through the voyage without.
Well, she may have improper trim, which is a matter of judgment prior to departing.
My lord, before I get to the trim example, in relation to, for example, stowage, and this is terribly important, one has to look at the defect. The defect is not the stowage plan, the ballast plan, the bunker plan. The defect is unstable, insufficient ballast, insufficient bunkers. And that is the defect for the purposes of the Mcfadden Test.
Well, isn't the consequence here of the defective passage plan that there is a defective chart, according to the judge's finding in 70?
No, there's not a defective chart. I'm going to come to that in the respondent's notice, but I'll do it now.
It's a chart which hasn't been properly prepared for the function it has to perform on this voyage.
With respect, my lord, no, because the respondent's the chart, the law, Mr. Justice Teare said on the chart you should have, having read the notice to mariners and planned your passage, you should put a warning at the top of the chart.
Why isn't that a finding at 70, the end of 70 and at 73 it was a defective chart? In the present case, neither the passage plan nor the chart contained the necessary warning.
My lord,
It's a defective chart, isn't it?
no, my lord, the chart is not defective. If you had rung up
You're missing the point. The defect in the chart is failing to put a warning on it.
No, my lord, the chart is the proper chart for the voyage, and it has been properly updated.
But it's a misleading chart because it doesn't contain the warning. That is what was causative of the grounding in this case.
No.
If he'd put the warning on the chart, none of this would have happened.
No, my lord.
The judge says expressly in 73, second line, it was therefore defective.
Or inadequate, and imprudently so.
For navigation, my lords, as part of the passage plan. My lords, your lordship's obviously concerned about this point, so let me develop it. The UK Hydrographic Office, if we said, please give us the most up-to-date chart for leaving Jeanne-Men on the 17th of May, they would have sent the chart we have. It doesn't have, and my Lord Justice Haddon-Cave has just taken it out, it doesn't have the warning printed at the top of the chart.
I don't think we have failed to understand that. I think it's just that we don't understand why the chart was not defective for this voyage. What's your
The
submission?
physical
about that?
chart is the physical chart. It comes out of the hydrographic office. Nobody's suggesting there's something wrong, intrinsically wrong with the printed chart. The point the judge is making is that the chart was defective because the master and crew had not put the necessary warning on it.
The chart was defective as a document which records part of the passage plan. That's my answer. The chart is defective because the chart is part of the passage plan. Now, I've already taken your lordships through that. The chart is part of the passage plan, and it was defective because as part of passage planning and recording the planning, they should have had that written at the top. The chart was not defective in the sense that it was not the proper chart to plan your passage on. It was, and it was an up-to-date chart. It was. So that's the distinction. It can't be both, and I've made this point in my skeleton, but I'll just say it orally. It can't be both. You can't have. You have to passage plan on the most up-to-date charts that are appropriate for the voyage. The up-to-date charts are the ones you get from the hydrographic office, and I've shown your lordship this chart did not require. This chart did not contain the warning at the top, and the notice to mariners. The very next one, following the notice of mariners, which contains all the details, said the only amendment you need to do to the chart is to change the legend. So the chart is the chart. You passage plan on a chart, and as part of passage planning, therefore, it should have been updated. You can't have both. It can't be a defective chart and then used for passage planning. My lords, just finishing off on my section 3. Just take one moment. I think I've made these points. I'm going to move on, my lords, to section 5, which is due diligence. My lords, section 5, my lord, there is another, we say, fundamental principle, which we would invite your lordships to consider. We say it's well established that the nature of the carrier's obligations under Article 3, Rule 1 is limited to acts carried out by third parties qua carrier. So let me explain that. We accept that whoever is doing the act, the owner is liable for their negligence, but it's only if that person doing the act is doing an act which otherwise the carrier is obliged to do, not typically does, is obliged to do under Article 3.
If the effect of the defects as found by the judge in the chart and the passage plan, paragraph 70 and 73, is that the vessel runs aground, so that the cargo interests incur potentially damage to cargo and potentially liability for general average, delay, etc., etc. Why isn't that part of the owner's obligation as the carrier?
Because I go back to where I started.
It's a totally artificial distinction, this one. It doesn't seem to me that this adds to your I mean, if you're wrong on your first ground of appeal, then it seems to me, I know I gave you permission on both, but it does seem to me on reflection that the second one doesn't run if you're wrong on the first one.
With respect, it does, if I can explain why I think it does. It goes back to the distinction we made right at the beginning of our submissions. The obligation qua carrier under Article 3, Rule 1 is to put on board all the requisite materials that are needed for safe navigation. 2, to give appropriate instructions and guidance to the crew as to how to conduct safe navigation, i.e. the SMS system. And 3, ensure that the vessel is competently crewed, that she has competent crew. That is the obligation of the carrier. The obligation of the navigators, quae navigators, is to navigate the vessel. It is not the obligation of the carrier to navigate. And that's made very, there's a good example of that in the Kapitan Zakharov, which
Right.
I'll show you. But can I just finish the point? Therefore, if he has done everything, the carrier has, and put it all on board the vessel, then he's not responsible, quae carrier, for the failure to navigate carefully. Now, we say, and I said this in opening, there is a residual point here, which is even if you're against me and you find that the chart or the passage plan, the one-off defective passage plan, renders the vessel unseaworthy, the owner used due diligence, exercised all due diligence to make the vessel seaworthy because he put on board all the equipment, gave all the instructions, and employed competent crew.
But that with respect to Spain, that's precisely the point that I was putting to you, that if you're wrong and the vessel was rendered unseaworthy, then on the face of it, that's because the owner was in breach of its non-delegable duty under Article 3, Rule 1 of the Hague Rules.
If she's unseaworthy, unseaworthy is an issue of fact, and what it is
It doesn't get you anywhere unless it's. None of it matters unless it's a breach of Article 3, Rule 1.
Well, no.
Where Parche, Mr. Russell, the received wisdom is that the burden of proof is on the cargo interests.
Well,
and then the burden shifts to the owner under Article 4, Rule 1, to show due diligence to exercise to make the vessel seaworthy. And if the owner establishes due diligence, then he gets off.
According to Mr. Russell, and the way in which the case has been argued so far, is the Mcfadden Test. You just apply the Mcfadden Test. You say, is this defect one which a reasonably prudent owner would require to be repaired before he departed the berth? And if it is, the vessel is unseaworthy. Now, therefore, if a reasonably prudent owner would require a defective passage plan not to be defective before he leaves the berth, the vessel is unseaworthy. The question is, did that reasonably prudent owner, or did my clients, exercise due diligence before the commencement of the voyage to make the vessel seaworthy? And the answer to your lordship's questions are yes, because he put on board all the equipment, he gave all the instructions, and he employed competent crew. And that is why it's a residual case, and that's why your lordship was right to grant permission on that point, because it's a residual point. And it comes out very nicely from the Kapitan Zakharov, which if we can look at that now, it's tab 23, which is in the first authorities bundle. Now, this, you know the facts, I think your lordship knows the facts in this case. It's the container of dangerous cargo on deck, which had not been declared dangerous, and there was also a dangerous cargo under deck, which had been declared dangerous. And the judge held that the dangerous cargo on deck, even though it had not been declared, rendered the vessel unseaworthy. And you get that from page 272. Now, it's really where we go. Sorry, I've got a wrong reference there. I'm in the wrong tab. Sorry, my lords. Yes, 272. Now, it's a question of where we go from there. Now, my lords, if one looks at 272, right-hand side, starting just, sorry, one moment, my lords, if I may. Yes. If one goes to the right-hand column, starting first paragraph, Lord Keith, he quotes Risto Meat.
271.
272. He quotes Riverstone Meat, and he says, however, it's plain from the context of that case that the disrepair of a ship and of his reasoning in the passage from his speech I have set out, that he did not extend it to a responsibility for the conduct of manufacturers or exporters or of shippers in their stuffing of containers and description of their contents, see also Maxim Footwear. In my view, there is no warrant in the facts of these cases or the rationales of them for extending a carrier's duty of due diligence as to the structure and stowage of its ship to a physical verification of the declared contents of the containers or other packaging in which cargo is shipped, unless put on notice to do so. Mr. MacDonald observed in the case of shipper-pack containers that nowadays they get locked. Next paragraph. This is important, my lords. In addition, to impose such a responsibility under Article 3, Rule 1 on the carrier for this shipment of undeclared dangerous goods in a sealed container would run counter to the scheme of Article 4, Rule 2, which accepts in general terms for liability in a number of respects, fire, latent defects, other matters arising out the fault of privity. You've also got, of course, Article I, which is shipper's neglect. Then he says...
This is all about shippers' misconduct and latent defect. How does that help?
You've got to look at the context of this. The context is, go back to page 271, left-hand column, and just look at the width of the submission that was being addressed by Mr. Milligan on behalf of the relevant party. It was an extraordinary submission, the effect of which was, even though the owners didn't know that any of these containers had stuff that went bang inside them, and the shippers did, the owners were responsible for the negligence of the shippers going right the way back to the stuffing of the containers. Had to establish due diligence. It was exercised by all concerned in the manufacture, packing, transport and storage of the cargo before shipping.
My lord, I accept that. Can I make my points, please? What we're saying is it's a matter of construction. I'm making really, with respect, a different point here. Mr. Milligan says, and I now hesitate to use his name, Mr. Milligan says at the bottom of the right-hand column on page 272, Mr. Milligan sought to overcome that difficulty by submitting. So that's the difficulty. The difficulty is the structure of the rules. This is an analysis. He says, Article 3, Rule 1 is defined or delimited by Article 4, Rule 2. And he says Mr. Milligan sought to overcome that difficulty by submitting that Article 4, Rule 2 exceptions are concerned with the carrier's responsibility for handling the cargo under Article 3, Rule 2, not its obligation to provide a seaworthy ship under Article 4, 1. His argument, therefore, was that where there is an issue, where the issue is one of due diligence in providing a seaworthy ship, as distinct from one of the careful handling of the cargo, the carrier has an absolute duty rendering it responsible for the misconduct of shippers and others to whom it has no control, etc. The difficulty in that submission, as he acknowledged, involves an open-ended extension of Riverstone Mead itself, as unseaworthiness case, the ratio of which was the carrier cannot absolve itself from its personal duty of due diligence by delegating the responsibility, italics in the original, as a carrier, to an independent contractor. The shipper and the carrier's respective orbits of responsibility, your lordship wanted to know where I got that phrase from, it's here, are normally quite distinct, and neither is the agent of the other outside its own orbit. Those responsible for manufacturing, stuffing and shipping of containers are plainly not carrying out any part of the carrier's function for which he should be held responsible. Just pausing there, my lords, exactly the same in relation to navigation.
Well, it isn't, with respect. That's the whole point. The whole point is that this is a distinction between the owner as carrier and the limits of responsibility under the Hague Rules, the orbits of responsibility, if you want to talk about that. I mean, in a sense, I can't remember now whether Pyre and Incendiary was cited in this case, but it's the same sort of thinking that lies behind Pyre and Incendiary, isn't it? You know, where does the orbit, if you like, or the responsibility of the owner, qua carrier, begin? And that's the point Lord Justice Alder's making. He's not dealing at all with once the goods are in the possession of the owner, once the goods are on board the ship, who's responsible for seaworthiness thereafter.
My lords, I submit there is a broad point here, and can I make it? Yeah. The broader point is this, that you look at the Hague Rules, and that's the point about construing Article 3, Rule 1 against the Article 4, 2a exceptions. And what you do is you say that informs the person doing the exercise as to the extent or the orbit of the responsibility of the carrier as a carrier. And just like under the Hague Rules, you are not responsible under 4.2i for acts of shippers, for example, and therefore that delimits the scope or the breadth of the obligation of seaworthiness under Article 3, Rule 1. Exactly the same applies, we say, in this case. You look at Article 4.2a, it is a time-honoured exception that errors of navigation are matters for navigators, for the crew. It says errors of the master and crew. And if it is an error of the master and crew, it is out with the orbit of responsibility of the carrier under Article 3, Rule 1. And that is why, with respect, my lords, I submit owner's submissions here before you are entirely coherent. The obligation on the carrier under 3 Rule 1 is to make the vessel seaworthy by giving her all of the equipment, all of the instructions, and competent crew. Once he's done that, you've done your job qua carrier, and then if there is an error in navigation qua navigators, which would otherwise be an Article 4 Rule 2a exception because it is an error of navigation by the master, that is not something that falls within the orbit of responsibility of the owner, carrier, under Article 3, Rule 1. And that's the submission. And Lady Justice Gloucester in the Happy Ranger,
Where's that?
if one looks at the Happy Ranger, which is in tab 28, because that's the next authority bundle.
Yeah.
She, my lord, tab 28, the relevant part to look at, if I can just I'm running out of time, so I can take it very quickly. If you turn to page 653, my lords, if you look at paragraph, left-hand side, paragraph 19, the Lady Justice starts with the Anglis case, which is by the first hole punch, which is the orbit of responsibility. And this is all to do with before the vessel was purchased type case. You know, when does it come within the orbit of responsibility of the owner? Is he liable for the builder's errors and before he purchased the vessel? Then she says at paragraph 20, the same principle was applied more recently in the Kapitan Zakharov. The Kapitan Zakharov illustrates that the relevant failure to exercise due diligence must relate to the performance of a function undertaken by the subcontractor as a carrier on behalf of the carrier rather than in an alternative capacity. Now in that case I accept it was the shipper. But that's why I've called it a fundamental principle, my third fundamental principle. It's not limited to just shippers. It's not limited to the shipyard that built your vessel. Article 3, Rule 1 only goes so far as it falls within the carrier's responsibility qua carrier. And that's certainly how the textbook writers see the point. If your lordships turn to voice charters, which you'll see in tab 44, paragraph 100, 85-100 on page 1026. Under the heading, the duty is non-delegable. However, not all, this is paragraph 100, 85-100, however, not all failings which led to a vessel being unseaworthy are thus attributable to the carrier. The relevant want of due diligence must be by someone performing the functions undertaken in the capacity of the carrier, not in some other capacity, and for that he cites, the author cites the Kapitan Zakharov. And that's the point. The function of navigating is not a function of the carrier qua carrier. It's a short point.
But there is no case, excuse me, there is no case so far, is there, where an action by the master or the crew has been held to be outside the orbit of the ship owner.
In terms of unseaworthiness?
Yes.
Because two reasons. Yes, I
What's the
don't
answer to
know
the
what.
question?
I mean, the master or the crew do something which renders the ship unseaworthy. That's the premise for this part of the argument.
I think that's correct. I haven't found one. Two reasons. One is because most of the time it will be an error in management, and if it's an error of management, my lords, that will, generally speaking, it's management in the vessel, and it will render the vessel unseaworthy because it will somehow affect the attributes of the ship.
You said in answer to the question from me earlier on, I think, that Article 4, Rule 2, half of it falls if there's a breach of Article 3, Rule 1, the other half doesn't. I mean, I think I paraphrased, but I took it that was your submission. So if it's management and the master and the crew are responsible...
But it has to affect the attributes of the ship.
Well, it has to... That's going around in circles with respect. If it is before and at the beginning of the voyage and it otherwise amounts to unseaworthiness, you accept that if the master and the crew have failed in the management of the vessel, there's no defence available under 4.2a. If it's unseaworthy.
In the management of the vessel. My lords,
Take an example. We've said several times, the owner equips the ship crew with everything they need, for instance, to load and trim the cargo correctly to make sure that it's stable.
yes,
But on one occasion, a one-off occasion, it's not done properly.
because
The ship therefore leaves the berth and sinks pretty quickly because it's unseaworthy.
yes, that is because at the commencement of the voyage, there is a problem with the failure in management of the ship has caused an attribute to the vessel, which means she is
It's a separate point. The first part of the proposition which my lord put to you is that you accept, subject to it being an attribute of the ship, and there's no defence.
Well, if it goes to an attribute of the ship, that is primary within the orbit of responsibility of the carrier. But that's why I don't think these examples, with respect, my
You
lord,
don't submit these examples.
well, my lord, that is why I don't submit these examples, my lord, are particularly take the debate much further, because
Well, we've got your submission about this.
Well-
We can read the Captain's Sakharov. It's now 3 o'clock.
I'm going to. I was just going to tell your lordship, and you'll see it on my roadmap. The Teare, we say, and the Jai Lihai can be construed in those ways as well.
Yeah.
Respondents notice, my lords, I've dealt with the working charter not properly updated. My learned friend sent me an email last night saying he's not going to advance the Vol Cafe point any further. Anymore.
He'd have some difficulty with it, I think, because there are it's fairly well established. It might be said only in first instance authorities, but first instance authorities as eminent as Mr. Justice McNair and Mr. Justice Lloyd in respectively the Reardon-Smith case and the Hellenic Dolphin. And whatever else Lord Sumption was doing, as I said earlier on, I don't think he was going anywhere near this point. So you needn't trouble us with that.
And then on 7B, my lords, just about proper systems, my learned friend has a respondent's notice that says,
Well, he can develop those
And
points
I was
in
going
his
to
submission
say-
to the extent he needs to, but if you're wrong on your main submissions, then none of that rises, does it?
correct, my lords, so therefore that's...
Well, let's leave that for reply, Mr.
My lords, it's 3 o'clock, I'll sit down, my lords. I'm grateful for your lordships.
Thank you. Yes, Mr. Russell.
My lords, at the very start, can I apologise again? I hope you had our email apology last week. Apologise for the error that occurred in our skeleton arguments in relation to the citation from the Aquacharm. Well, in that case, can I ensure that you've got the corrected version of the skeleton arguments in your bundle? If you take the...
I think we have, haven't we? Because I think there's been something described as a replacement skeleton.
Alas, our replacement skeleton also contained an error in it. I'm afraid it's a matter we're taking very seriously. We put into a citation from Lord Denning's speech words which were not in the citation. So
No.
what was meant to be a submission got put into the citation and was then repeated.
I think. Where is it exactly?
So you can find, if you look in tab...
It's paragraphs. We've got it in your amended version at page 62. You've crossed out the citation from Lord Denny,
Yes.
and you've said a failure to exercise
Yes.
proceeding.
Yes. Well, I'm very grateful that Your Lordship's got the right version. And again, I can only apologise for the fact that the error was made
Thank you very much.
in the first place. Look, what I propose to do is start by going to the key factual findings in the judgment. You've looked at those, or some of them at least, already. And then explain why we say our case is right in very simple terms. If Your Lordships go to the judgment, which is at tab 7 of the core bundle, the first paragraph that we say is key is paragraph 70. 70, which is on page 92 of the bundle. And the judge says at the start of the paragraph, nevertheless, prudent passage planning required the danger created by the presence of numerous depths less than those charted outside the fairway to be noted on the chart. Then he discusses the expert evidence, and there's a conflict of the evidence, and he concludes at the end, my conclusion, having considered the expert and other evidence, is that whilst it would of course be prudent to note the warning in the passage plan, it would also be necessary and prudent to mark the warning on the chart, since that is the primary document to which the officer navigating the vessel would refer when making navigational decisions in the course of the outward passage. And then he says at 73, at the foot of the page, in the present case, neither the passage plan nor the chart contained the necessary warning. It was therefore defective or inadequate, and imprudently so. A source of danger, when leaving Jamin, was not clearly marked as it ought to have been. Now, there could be no more clear finding of fact than that the warning that appears in the notice to mariners, that there are numerous depths less than charted outside the fairway, should have been written on the chart before the beginning of the voyage. In the next section, the judge then goes on to consider unseaworthiness. And the key finding of fact is in paragraph 78, where he discusses the requirements of the 1999 IMO resolution. And then, applying the Mcfadden Test, he says in the last sentence of that paragraph, it seems to me inconceivable.
So we are. Oh yeah, last sentence. You've got you. Yeah.
It seems to me inconceivable that the prudent owner would allow the vessel to depart from Jamin with a passage plan which was defective in the manner which I have found. And as we've seen, that manner was in that the chart did not have the relevant warning written on it prior to departure. And then causation isn't an issue. He dealt with causation at paragraphs 89 and 90. It's not an issue on appeal. But just so you have those passages, at the end of 89, at the top of page 98, it says, my conclusion is that whether or not the master had read the notice to mariners before the voyage to Jamin, its contents were not in his mind when navigating from Jamin. Thus, it is more likely than not that the defect in the passage plan was causative of the master's decision to leave the buoy to port, in other words, to leave the fairway. Paragraph 90.
That finding is not challenged on appeal.
That's not challenged. Well, it's a pure finding of fact, so it couldn't be. I think he goes on to say, it's submitted that the master would have made the same decision as he in fact did, even if the chart or passage plan contained a warning as to charted depths. Yeah. I'm unable to accept that submission. Look, putting it in very simple terms, we've got the reconstruction of the working chart in, I think it's tab 3 in the bundle. The original went missing at some stage in the litigation process, and so this is put together from various photographs that were taken.
Yes. I know that my Lord Justice Haddon-Cave wants you to get the chart out. So you've already got these dividers out.
I didn't bring my divider today on the basis that it takes about 15 minutes to persuade security that it's not an offensive weapon. But what we have is before the part.
Tab 4, is it?
There are two versions. There's
a clean version at tab 3, tab 5.
Yes.
Which is tab 4, is it? Yeah, it's got the.
Yeah, so 4 is
the one that's got the passage plan on it.
Yes, it's got. Yes, it's got the
course.
The course, yes.
Yeah.
What we have when we tie this into the judge's findings is we have this identified as the chart that is required for the departure. It's on the chart table. It's to be used as the primary tool for navigation for leaving the port, the port, and it is defective. It is defective because it does not have the warning as to charted depths outside the fairway written on it. That is a dangerous defect because it lures the master into a false sense of security that he may have deep water where it is shown on the chart, when in fact he does not have deep water to navigate in. That is precisely the trap that the master fell into in this case, because he thought it was safe to leave the void channel and navigate west of the Zhujiao Islands, because there are no shoals shown on the chart, or no complete shoal area, and because the warning was not written on the chart, he thought it was safe to do that when it was not, and that the judge has found that the defect was such that it was inconceivable that any prudent owner would allow the vessel to go to sea with the chart in that defective condition. In our submission, the
master's, it's the point about paragraph 90, isn't it? The master accepted in cross-examination that if the chart had been marked with a warning, he wouldn't have engaged in the manoeuvre which led him down this course, which was the manoeuvre around Bull Boy 15.
Yes, exactly. I think the master's precise concession in cross-examination was that if a no-go area had been marked, he wouldn't have left the.
Yes, he eventually conceded that.
Yes, he conceded that, and then the judge extrapolates from that if the warning had been on the chart, he wouldn't have left the void channel.
Yeah.
And we have
the fairway is only sort of cable and a half. It's a very narrow cable.
It's narrow, yes.
It is quite narrow, isn't it?
The void, what's referred to as the pecked or the dredge channel is narrower than the void channel, but neither are particularly wide. But as I say, we have a finding of fact that it is inconceivable that any prudent owner would allow the vessel to go to sea with the chart in this defective state. And we say that the chart is quite plainly an attribute of the vessel. A defective chart goes to seaworthiness. The chart was defective because the master failed to exercise due diligence. The owners are liable for that failure to exercise due diligence on the straightforward application of the non-delegability principle. And that is the end of the case.
You, in a sense, rely on the facts themselves to demonstrate the unseaworthiness. A simpler example would be if a huge great rock was right in the middle of where the passage had been laid out, bang, it was pretty inevitable there was going to be, the ship was going to hit it. So you rely on the facts themselves to demonstrate unseaworthiness.
Yes, we say that this, as the judge himself said, I think in both his judgment and in his reasons for refusing permission to appeal, this is a straightforward application of orthodox principles to the particular facts of this case.
You've submitted that a chart is an attribute of the vessel.
Yes.
Do you accept that for there to be unseaworthiness, there has to be a failure in the attributes of the vessel, whatever that may mean?
I wouldn't make that concession. We say that you do not need to do more than apply the Mcfadden Test as it stands. But if an attribute or a defect in an attribute of the vessel needs to be found, there are a few clearer examples than the chart that is to be used for the navigation of the vessel out of the port.
I follow. Did the judge simply apply the Mcfadden Test, or did he go on to look at the question of attributes?
The way in which the judgment is structured is very much an application of the Mcfadden Test. He had to deal with an argument based on the Teare that a one-off failure navigation is somehow out with the scope of the test. I confess I can't recall whether the argument was expressly put in terms of attributes or not.
But because if it was, because the judge would have dealt with it otherwise.
Yes, I'm hesitant.
The argument based on Teare and the Jiaolia High was clearly
yes,
run, and the judge deals with that at 82 to 84. Right?
Yes, the thrust of it was that there were two main thrusts, I think it's fair to say. One was that a one-off defect in the passage plan didn't go to unseaworthiness because it was a navigational matter. And then there was the capacity argument, the owner not being responsible for a failure by the master to exercise due diligence if the master was acting qua navigator rather than qua carrier. But as to that, I mean, what we say in relation to the orbit point, which is what my friend relies on in relation to capacity, everything that the master does relating to the safe prosecution of the voyage is within the orbit of the carrier. The orbit cases deal with the competing orbits or the separate orbits of shipbuilder and carrier or shipper and carrier. But once you're looking at the safe prosecution of the voyage, everything
that's the point, though, isn't it? I mean, if you look at those cases, like if you look at what Lord Justice Ord says in the Captain Sackett for what Mrs. Justice Foster says in the Hague Rules, they're dealing with the infinite regression point, which is that, you know, going way back in time, can you hold the owner responsible for stuff that's happened before his responsibility begins, which is the same point as Pyron and Cindy.
Yes.
And the answer is no.
No.
But once you're within the area where the owner has become responsible for the cargo, under Article 3, Rule 2, and also become responsible for the seaworthiness of the vessel under 3.1, it's a different question, isn't it?
Yes, it's plainly within the orbit of the carrier then. And it's in my submission, wrong when you're looking at the issues that are before this court to say that because negligent navigation and management is an exception to the carrier's liability under 3.2, it is not within their orbit. In my submission, it actually cuts the other way. And the fact that it is an accepted cause of what would otherwise be a breach of 3.2 demonstrates that it is within the carrier's orbit or sphere of responsibility. But you have carved out of what would otherwise be liability for breach certain exceptions.
And you have a clear finding of the fact that the cause was the defective plan stroke chart.
Yes, if the chart had been defective, the master would not have left the channel and would not have run aground on the shoal which he ran aground on. The reason why the vessel went aground was because the chart was defective, because the warning that should have been written on the chart was not written on the chart. Those are all primary findings of fact, and they lead inescapably to the conclusion that the judge reached.
What do you say to Mr. Hill's general point that this is all navigation, quote unquote? What acts of navigation, as he put it?
Well, whatever the steps that lead up to the chart being defective, the outcome is the fact that before departure, we say the vessel is defective because there is a defective chart on board. To say that the preparation of that chart is an act of navigation doesn't assist the owners in this case, because acts of navigation are not an accepted cause to 3.1. We say that the judge was right to characterise them as acts preparatory to navigation, but even if they are characterised as acts of navigation, that does not assist, that's not a conceptual barrier to 3.1 applying. Mr. Hill made a concession that acts of negligent navigation can lead to liability under 3.1 if they lead to a defective attribute of the ship. He gave the example of negligent navigation on arrival leading to a collision with the dock and a crack in the structure of the hull. So, although his argument in the written case appears to turn on the navigational aspect, in fact, the guts of it appeared to be in his oral submissions, that the submission that he made, that the reason why navigation is different is because negligent navigation will only rarely lead to a defect in an attribute of the ship. He said it was inherently unlikely that a negligent act of navigation prior to departure would lead to a defect in an attribute of the ship. But in this case, if you characterise it as a navigational fault or navigational matter, it has led to a defect in an attribute of the ship. And if the chart that is being used to navigate the vessel out of the port is defective in some way, it doesn't matter that the reason for that is that the owners or the master have ordered the wrong chart, or that the navigating officer has failed to mechanically update it properly in response to a notice to mariners that requires a mechanical updating, or that a warning that requires an element of judgment to be applied hasn't been applied to the chart. In terms of the attributes analysis, the result is exactly the same. You have the vessel prior to departure in a dangerous state, in a state in which no prudent master would allow her to depart, because part of her equipment, the chart, the key piece of equipment for departing this port safely, is defective.
Would you accept that different aspects of passage planning, or some aspects of passage planning, may fall outside the concept of seaworthiness? For example, if you have a statement in a passage plan that there should be a conversation between the master and the pilots, that they discuss what they're going to do. Is that something which, if it's not there, renders the ship unseaworthy?
We would say it does. It is. You have then plainly a wider concept of if an attribute of the ship is required, you would have a wider concept of an attribute of a ship than a physical piece of paper. But we would say that if it is not safe for the vessel to go to sea, unless and until the master and pilot have had a proper exchange, then the vessel is unseaworthy if the if that exchange has not taken place. Now, I accept that that may be a case that is a more difficult case than that which your lordships have to decide. But your lordships, to decide this case, don't have to explore the outer edges of the concept.
Well, you would say the chart's defective for the reasons you've given. Why the chart's defective doesn't matter for present purposes. The fact that it was defective, and no prudent owner would have allowed a ship to go to sea with that defective chart because it endangered the safety of the ship and cargo.
Yes, and this is where
you say, well, that involves it being an attribute of the ship is in a sense a gloss on that point, isn't it?
yes, if it's being an attribute of the ship is required, it plainly is in this case, because ultimately, as I understood it, the way in which my friend put his case on navigation was that navigation is different when it comes to unseaworthiness, because it's inherently unlikely that a navigational error will lead to a defect in an attribute of the ship. Well, in this case, it has. There's nothing conceptually special about a navigational issue in relation to the 3.1. In the rules, navigation as an exception only appears in 4.2a alongside management. There's no
I think Maxine Footwear is high appellate authority for the proposition that the exceptions in Article 4 Rule 2 don't bite in relation to Article 3 Rule 1 duty, full stop.
Exactly, and
That was a fire case, wasn't it?
fire case. It's one of the cases to which I'll take your lordships in due course. Fire case, very good example also of how the temporal divide in the rules results in the same act or event leading to liability in some circumstances, but not others. There was, in fact, a discussion in the judgment below of the attributes point, and it's at paragraph 85, which is page 96 of the bundle.
Oh, yes, yes.
And the judge holds towards the middle of that paragraph, it's well recognised that if the vessel's charts are not up to date, that is an attribute of the vessel or intrinsic to the vessel, which can render her unseaworthy.
And you say really that's the end of the matter?
I do.
Well, clearly, if they hadn't amended the chart to include the most up-to-date notice to mariners that had to be put on the chart with tracing paper or whatever, then that would have made it a defective chart. And you say, well, the fact that this would involve an exercise of judgment as to whether the warnings that were in the 627410 should be written on the chart in one way or another. Doesn't matter whether that's an exercise of judgment because the end result is still a defective chart.
Yes, exactly. And as I think probably each of your lordships has said, there are many matters that go to unseaworthiness that require an exercise of judgment. So how the ship is ballasted, how the stowage is conducted to ensure that the vessel is stable, stability calculations all require exercise of judgment. Even the engineering cases, this is set out in our written submissions. In an engineering case, a chief engineer may have to take a view as to whether a part should be replaced before the voyage takes place, or whether they can get by to the next port.
And at all events, you have a clear finding of fact that this defect rendered the ship unseaworthy.
Yes, we do. And my friend, for understandable reasons, tries to separate out passage planning and chart updating and the chart. But what we have in this case is, in my submission, a plain finding of fact that the chart was defective. The chart should have had a warning written on it, and it didn't. But perhaps I can deal with a factual point just at this stage, because it relates to the updating. We say it doesn't make any difference whether there's a mechanical updating or not. But it's worth perhaps just looking at the notices to mariners in this case. So if you have the...
Do we need the chart anymore?
If we go to it again, it'll only be so I can repeat the points I've already made. So I hope not. If you have the second supplemental bundle,
Yeah.
at tab 1, you have notice to mariners 6275/10, and that is prescriptive in terms of what is to be marked on the chart. And over the page you have the tracing from notice to mariners 1691/11, and obviously the tracing is again prescriptive in terms of the new shoals that have been marked on the chart. But if we look at the notice to mariners that we're concerned about in this case, that's in the main supplemental bundle at tab 6. So you can ignore the bit at the top. That's a different notice to mariners dealing with Portugal, and you get to the one that we're concerned with between the two hole punches, 6274P 2010. And you can see that there is a lot of information set out there. Some of it is quite specific. So you've specific shallows or depths less than charted identified in paragraph 2. Then you have the more general wording of the warning in paragraph 2 itself. Numerous depths less than charted exist within and in the approaches to Jiamen-Jiang. No significant are as follows. And then they're set out. And then, for example, at 3, a very specific point, a radar beacon exists at Light Buoy. But you'll note that there's no prescription here as to what is to be written on the chart.
There's no easy tracing here.
There's no easy tracing, but nor is there simply go to this that is written on the chart, delete it and amend it, as we saw in the one we looked at in tab 1. It's there are no directions to the navigating officer as to what he has to do. So when this arrives on the vessel, the navigating officer and the master who supervises do have to exercise skill and judgment in terms of how they translate this warning to or this information to the chart. And so to say that there's a bright line between updating the chart, which is purely mechanical, and passage planning, which is requires an exercise of skill and judgment, it's a false dichotomy. I mean, it doesn't. We said it doesn't matter anyway that whether the defect is caused by a mechanical failing or a failing that requires skill and judgment. But as a matter of fact, not all notices to mariners are prescriptive and purely mechanical.
And the judge dealt with this and he considered the option of hatching. The problem with hatching is you can obscure more of the chart than is a good idea.
Yes,
it's not an easy thing to deal with. It requires judgment, and sometimes you may hatch, sometimes you may put a large red finger on it saying this is a danger area.
Yeah, with those
the judge analysed all of that quite carefully.
And the judge said in the end that the very least that should have been on the chart was a warning, written warning,
Yes.
saying there are the depths shown on the chart outside the fairway are unreliable. See Notice to Mariner 6274/10.
Exactly. Yes. There was quite a lot.
They tried. The owners tried to argue, didn't they? That, it was enough if it was on the chart table, or if it was pinned to the back of the chart, or something of that kind. And the judge said, "Well, I'm not." He wasn't satisfied on the fact that it was pinned to the back of the chart, but he said that wouldn't have been enough. That wasn't good enough.
Exactly. So the key debate ultimately was the one that is set out in the wrong bundle. It's the core bundle. I mean, there were arguments both sides that the judge rejected. I mean, our primary case was that everything outside the channel should have been hatched as no view area. And the judge considered that would have made the chart too busy. My submission on that was it didn't matter it was too busy because you shouldn't be there anyway. You're only obscuring information.
If the only bit that was safe was the narrow bit down the channel,
Yeah.
you were presumably saying well, it didn't matter whether it
Well,
was
yes,
as busy as could be on either side.
Busy as you like. You should
Anybody reading the chart would see, well, hang on a moment, the only
Yeah.
bit that looks clear is that.
So the judge rejected that. He rejected an argument the other way that was advanced by Captain White, who is sadly no longer with us, in paragraph 70.
71, is it? Yeah.
It was 71. No, 71 is slightly different. That was a bizarre argument where Captain White said that a tiny little area
With the no-go.
could be a no area.
Spot, yeah.
It's really 70 where Captain White said that putting the warning on the typed up document would be sufficient. But the judge rejected that. It wasn't there anyway. The judge rejected that and said, in this case, finding a fact, the warning has to be written on the chart. It wasn't, therefore the chart was defective. It was defective in a dangerous way, defective in a way in which it was inconceivable that any prudent owner would allow the vessel to go to sea.
So the judge took a middle course, in a sense, between the two extreme arguments.
Yes. Yes. If the master had taken the middle course, none of this would ever have happened.
Yeah, we will. The courts like to take a middle course, so carry on.
There is a further factual point that I want to make before I come on to the main body of my submissions.
Yeah.
And that is in relation to the distinction, or alleged distinction, between passage planning and chart updating. A point that the owners have made both in writing and in their oral submissions is that the writing of the warning on the chart is either updating the chart or it's passage planning, but it can't be both, as if they are conceptually different things. And in our submission, that's a wholly artificial distinction to draw. When the notice to mariners that we've looked at was received on board the vessel, it was incumbent on the navigating officer and the master to look at it and decide what information was to be extracted and noted on the chart. And the judge has obviously found if you're going to be using the chart to depart from Jamen, it's essential that you extract from the notice to mariners the written warning about depths less than charted existing and write it on the chart. But to say that chart updating and passage planning are quite separate is wrong when you look at the guidelines, which are in tab 2 of the supplemental bundle. And if one looks at the appraisal stage, process, which is at paragraph 2, it says all information relevant to the contemplated voyage or passage should be considered. The following items should be taken into account in voyage and passage planning. And there are various matters relating to the vessel, the cargo, the crew, and certificates. And then at 5, appropriate scale, accurate and up-to-date charts to be used for the intended voyage or passage, as well as any relevant permanent or temporary notices to mariners and existing radio navigational warnings. So, when notices to mariners come on board, there is a chart updating process, which may be mechanical or may require an exercise of skill and judgment. And then, when one comes to passage planning, at the appraisal stage, one of the first steps in the passage planning process is to make sure that you're working from all the right documents. And that will involve, amongst other things, making sure that the relevant and necessary information from notices to mariners has been translated to the working chart.
Yes, you said it's a two-stage process. You've got to make sure that you've got the right up-to-date documents, and then you passage plan.
Yes.
You've got to make sure you've got all the relevant notices to mariners,
Yes.
and looked at them and implemented them, and then you prepare your passage plan.
Exactly. Yes. But I do say that's the way in which the passage planning process works.
So in a sense, you say, depending on when this notice to mariners should actually went on board the ship. I'm not sure what evidence there is about, or there was about that, if any. Those on board with the responsibility, whether it's the second mate or whoever, should have noted the warning on the chart at that stage.
At that point, yes. Yes.
At that point.
Yes.
In any event.
Yes.
And then when it comes to passage planning, assuming that hadn't been done, that in itself would be a fault, putting it neutrally. When it comes to passage planning, if they ascertain that that hasn't been done, they should do it at that stage.
Yes. Yes.
But at that stage, the second stage, it is both updating the charts properly, which hasn't been done already,
Yes.
and passage planning.
Yes. But
That's your point.
Yes, to say that the two are entirely separate processes. And one of the areas where this is relevant, it's one of the grounds in which we oppose the amendment.
Yeah, that's why I wondered about that.
Yeah, because we may never get to this, but we say that the new point that is being argued for the first time is that unseaworthiness at Jamen is not enough to get us home in respect to the whole of the cargo. If that point had been taken in the pleadings or at the trial, then it would have been relevant to explore when the warning should have been put on the chart. In particular, should it have been put on the chart before departure from the first relevant load port, which is Hamburg?
And that would have required both factual evidence, both ways as it were, and expert evidence.
Yes, it would have required evidence as to when it should have gone on board, when it went on board, and factual evidence on those points, and expert evidence as to when it should have, when information from the notice to mariners should have been translated onto this chart, and what information should have been translated at this stage, and that inquiry never took place because it was never suggested that unseaworthiness at Jamen didn't get us home in relation to the normal cargo. That's what I wanted to say by way of introduction and touching on a number of factual points. We've boiled, or tried to boil our case down to a number of propositions. Perhaps if I could pass about a one-page document that sets out those propositions, and then I can take your lordships through them.
Yep. Thank you very much, Mr. Russell.
in the discussion that we've just had, we've touched on a number of these already. First is that there is a temporal cutoff which affects the relationship between 3.1 and 2 and 4.1 and 2. And the consequence of that is that the same act or negligent act or omission, which during the voyage would fall within a 4.2 exception to a breach of 3.2, may lead to liability under 3.1 if before the voyage it renders the vessel unseaworthy. That's a slightly, well, it's not slightly, it's a very inelegant sentence with a typographical error in it. But it's a relatively simple point when one looks at the structure of the rules. It falls out of the way in which the rules themselves are drafted. The 3.1 obligation in relation to seaworthiness attaches before and at the beginning of the voyage. 3.2 is without temporal limitation. But the exceptions are only exceptions to 3.2. They're not exceptions to 3.1. And the inevitable consequence of that is that it matters when an act or omission takes place. Secondly, we say that there are no conceptual limits to the types of defect which can constitute unseaworthiness if the prudent owner or the Mcfadden Test is satisfied. And
Is that another way of saying you don't need any attributes?
yes, it is. Though, as we discussed, if we do need attributes, we've clearly got one in this case, because we have the defective chart.
We were finding of the judge to that effect in 85.
Yes. Then, I mean, I'll go through some of the authorities later, if that's a helpful exercise.
Yeah.
But the types of defect which can constitute unseaworthiness, obviously physical defects in the hull or equipment, bad bunkers or insufficient bunkers, incompetent crew or delinquent crew, missing documents which are necessary to allow access to foreign ports. Even in one case, the fact that the vessel had at a previous port called it a plague port, so requiring fumigation.
Shampoo, isn't it?
Yes, that's right. Yeah.
Fumigation.
Yeah, which it's hard to analyse that in terms of an attribute of the vessel, because it was the mere fact that she had called at a plague port earlier in her journey, which rendered her unseaworthy. So she called it Mombasa, which is a plague port, then stopped at Naples to pick up a cargo of lemons, and went to Marseille. Had to be fumigated at Marseille because she had called Mombasa previously. Didn't have the deradicalization certificate. Held unseaworthy at Naples because it was inevitable that the fumigation that was required at Marseille would damage the lemons that had been loaded at Naples. Inadequate chart, wrong charts or inadequate charts are capable of rendering vessel unseaworthy. Poor systems, a dangerous cargo on board, as we've seen in the Captain Sakharov, can render the vessel unseaworthy. There are then questions as to whether there's been a failure to exercise due diligence or not. But we say there's no conceptual limit to the categories. And documents alone may render the vessel unseaworthy. Just to pick up on one of the examples that my learned friend gave, he said that where you have a defective stowage plan or negligently prepared stowage plan, it's not the stowage plan itself which renders the vessel unseaworthy. It's the fact that as a result of that, you have badly stowed cargo, which renders the vessel unstable. That's not that may be true in some cases, but it's also possible to posit a case where the stowage plan itself could render the vessel unseaworthy. Let us suppose that the vessel is loading cargo at port A and port B, and at port A stowage plan is drawn up which takes into account the cargo that will be loaded at A and B. And the stowage plan has been negligently prepared so that once the cargo is later loaded at port B, the vessel will be unstable and will capsize. We would say it would be the case that the vessel was unseaworthy before commencement from port A, even though she was at that point stable.
Yeah.
Because the plan at that point was to load cargo at port B in such a way that would imperil the cargo, the port A cargo.
So that's an example of the vessel being unseaworthy because of the plan.
Because of the plan, yes. And we would go further, I'd go further, and say that she would be unseaworthy if that was the plan, even though it wasn't written down. Let us say the plan isn't written down, but the plan is that all of the cargo, all of the port A and port B cargo is to be loaded on deck, let us say. And it's inevitable that if you load the cargo at both ports on deck, the vessel will be unstable and capsize. We would say that the vessel is unseaworthy at port A because that is the plan. Now, of course, we don't need to go that far, but we say there's no conceptual limits to the matters that can lead to unseaworthiness.
Yeah.
Well, these are just illustrations as to why it is that there aren't limitations on the concept of seaworthiness which Mr. Hill contends for.
Yes.
And the fact that there may not have been cases yet, or may never be cases involving a particular factual scenario, doesn't follow from that.
Well, there are all
limitations for which he contends.
There are all sorts of reasons why you don't have decided cases. An interesting illustration. I'll come to this. Probably the most powerful case in terms of statements and judgments as to the fact that defective charts render the vessel unseaworthy is the Derby. But the comments in the Derby about charts are obituary. We haven't found a clear case where a defective chart has been held as part of the ratio to render a vessel unseaworthy.
Derby is the case about the certificates, isn't it?
Yes.
Mr. Keeley's case.
Yes, I'll take you to that.
Is that the ITF case?
Yeah,
Yes, it is. That's right.
Yes.
So there's the vessel. Yes, the vessel.
Well, you'll show us that case.
I will, and what it says about charts. Point 3 really follows on from point 2. Point 3 in some ways is a subset of point 2. But failure to have necessary documents on board for, say, physical or legal prosecution of the voyage can constitute unseaworthiness. That certainly includes charts. We say it also includes passage plans. But in this case, the relevant document, which was part of the passage plan, was the chart in any event. Then we say that both one-off instances of negligence and systemic failings, so contrasting one-off cases of negligence with systemic failings, can cause unseaworthiness. A lot of the owner's skeleton focused on the one-off nature of the defect in this case. Now, as a matter of fact, the judge found that it was probable that previous passage plans have been defective as well, but we can look at the relevant passage on that when we come to the respondent's notice point if we need to. But in any event, it's not a relevant distinction, because most of the cases on seaworthiness, perhaps certainly most of the more modern cases, are cases where there has been a one-off act or omission role in systemic
Well,
failures.
if it were correct as a matter of analysis, you'd expect all the cases to be ones about system rather than about one-off failures, and they're clearly not.
Well, exactly. Or cases in which the judgments say, and this is another.
It's only happened once, therefore it's not unseaworthy.
Yes, exactly. I mean, but, you know, it's
However egregious it was.
the points do tie together as well, of course, because the reason why one-off events or episodes of negligence result in the vessel being unseaworthy is because of the non-delegable duty of due diligence. So you can't escape because you've got good systems in place if the person to whom you've delegated responsibility is negligent even on a one bad day. And if one unpacks it slightly, there are stages to the process of making the vessel seaworthy. So obviously, at the first stage, the owners have to ensure at a physical level the vessel is sound and fit for the cargo, fit for the voyage, and so forth. The owners have to recruit a competent master and crew, or engage competent independent contractors if repair work needs to be done to the vessel or something of that nature. They also have to put in place a proper ship management system and proper audit procedures to ensure that the systems that they've put in place are being implemented in practice. But ultimately, in most cases, the performance of the actual tasks that are required to ensure that the vessel is seaworthy to prosecute the voyage fall to be performed by one or more individuals. And if those individuals act negligently, as I say, even on a one-off basis, then that can lead to unseaworthiness under Article 3, Rule 1.
So I put an example to Mr. Hill of a seacock being left open before the vessel sets off. Why doesn't that render the ship unseaworthy?
Yes. Yes.
It's an act of an individual.
Yeah.
And the owners may have laid down systems, but it's still a classic example of unseaworthiness.
Well, the Herald of Free Enterprise, I mean, as it happened, there was, as I recall, the practice of leaving port without closing the bow doors.
Yes.
But it wouldn't have made any difference if in fact they had left the bow doors open, and a prudent ship owner would never have done that. It wouldn't make any difference whether it was done once or 1,000 times, would it?
Wouldn't make any difference.
I mean, it might make a difference, I suppose, to the issue of the exercise of due diligence in a particular case, that it's a one-off case, because in some cases the owners might be able to say the due diligence had been exercised.
Well, they might be able to say that due diligence had been exercised by them.
Yeah, I see your point. Yeah.
But because
if it's negligent, it's negligent. Yeah,
Yeah,
that's your point.
yeah.
Yeah.
So I mean, let's say there's a system.
Moncaster Castle, isn't it?
Yes, absolutely. Just so.
Yeah.
Let's say there's a case where there's a habitually the doors are left open because the ferry is running to a tight timetable and wants to get away as quickly as possible. Then you would be able to argue that the owners have failed to exercise due diligence because they haven't put in place a proper system. And you might say of the chap whose job it was to open the doors after the vessel, shut the doors after the vessel had departed, well, he was only doing what he was told. He can't be criticised. If the ship owners put a big flashing sign on the bridge which says "Make sure the doors are shut before you depart," the owners would say, "Well, we've exercised due diligence," but that avails them not if negligently the master set sail before the doors have been shut.
In fact, there was no sign on the bridge in the Herald of Free Enterprise. The vessels having been changed from a nose cone, where the bridge could see that it was open, to a clam door
Yes.
in 1980. And in fact, on this occasion, the boatswain fell asleep on his bunk reading a novel. And it was his job alone to shut the doors, and there was no system for checking the person who was checking the person shutting the doors. But it was, in a sense, on that occasion, a one-off, because he fell asleep. 198 people died in that case.
No, and it is a as you relate to the fact, it's a good illustration of how even if systems are in place, if there's a negligent failure, then there'll be unseaworthiness. But I mean, there are no end of cases to that effect.
And that case also demonstrates, in a sense, a different point, doesn't it? Which I think you've come on to, which is where does seamanship end and management begin? Or, how you put all sorts of labels on what's being done, but the focus under 3.1 is on whether the vessel is seaworthy or not.
Yes. Well, it really is the it's the next point that I've set out as proposition 5. The defects and or failings in the exercise of good seamanship relating to the navigation and or management of the ship can cause unseaworthiness. And there is obviously a degree of overlap between these points, but what we're saying there is that simply again it ties in with the first point. Simply because something would have been an accepted cause to a claim under 3.2 if it had taken place after departure does not prevent its leading to liability under 3.1 in circumstances where the vessel is thus rendered unseaworthy at the commencement of the voyage.
Because of the clear terms of Article 3.1.
Yes. Yes. Because of the clear terms of Article 3.1 and because 4.2 are only exceptions to 3.2 and not exceptions to 3.1. I mean, in a number of places in Learnfriend's written skeleton, he refers to the negligent navigation exception. And I'm afraid in my copy of it, I've sort of red ink written in large letters. No, it's not. It's just it's inaccurate to refer to it as an exception in this case, where the claim is being brought pursuant to 3.1, not to 3.2. So, as I say, failure to exercise good seamanship can cause unseaworthiness, and there are many examples of that in the authorities. And in the authorities, there are cases that we would say look pretty navigational in terms of the errors. So, a failure to calculate properly the distance to be run in order to put the
failure
to calculate the distance to be run.
Oh yeah.
To put the right bunkers on board or take into account adverse current and so forth, are plainly matters which we say at least relate to have a navigational aspect to them in the same way as passage planning has a navigational aspect. And I mean, simple matters such as, again, working out the stability of the vessel, working out a stowage plan requires exercise of good seamanship.
Because good seamanship encompasses navigation and management.
Yes, indeed.
They all lead to good seamanship, safety, seaworthiness, and so on.
Yes, absolutely. And again, you have the very important point that navigation and management, as an exception, are conjoined in 4.2a. There's no distinction drawn between navigation and management. So conceptually, one cannot say that there's any difference between navigation and management. One can't say that there's an historic carve-out for navigational matters, because there's no reflection of that in the rules. Navigation and management are both part of the same exception.
Indeed, on the plain wording of 3.1, it doesn't matter how the unseaworthiness comes about, whether it's navigation, management, a combination. It's a simple question, factual question is, was the ship unseaworthy at the commencement of the voyage?
Yes. And
which is what the judge found here.
Yes, exactly. And if one goes back to the trade-off that's inherent in the rules, that the trade-off, we say, is the different regime that applies before the commencement of the voyage, and the regime that applies after the commencement of the voyage. That was the balance that was struck between cargo interests and owners' interests when the rules were devised. Owners are liable on a non-delegable basis for the seaworthiness of the vessel at the commencement of the voyage.
We want our old exceptions
What,
for the course of the voyage.
once she goes to sea, then interesting. I mean, of course, not common law exceptions. I think that there's an error to that effect in their friend Skeleton. They weren't products of the common law. Those exceptions. They were contractual exceptions that were inserted by owners into their bills of lading.
These go right back to the early days, the Middle Ages of the adventure, where you prepared a ship. The investors invested in the ship, and you then sent it off.
Yes. Yes. Once just so you had your vessel bobbing in the harbour, you had to find a competent master and crew.
And an honest one,
Yes.
because it disappeared over the horizon.
Yeah. But once you've
Didn't see it for a year.
once you've put your competent master and crew onto your seaworthy vessel, then the exceptions apply.
Yeah. And it's interesting. Mr. Hill makes much of the Hill Harmony. Maybe you'll touch on that at some point. But looking at what Lord Hobhouse said at page 658 at sea, where he says the master remains responsible for the safety of the vessel, her crew and cargo, if an order is given compliance with which exposes a vessel to a risk which the owners have not agreed to bear, the master is entitled to refuse to obey it. That's in the context of clause 8 of the NYPE form.
Yes.
But if you it gives you that's why it's perfectly clear he's not dealing with questions of seaworthiness at all. But if you only need to turn that into a bill of lading scenario where the master being responsible for the safety of the vessel, her crew and cargo, and to set off as is would expose the vessel to a risk which the owners, which a prudent owner wouldn't agree to bear.
Yes.
That renders the ship unseaworthy.
Yes. May I just ask which passage your lordship?
658 at sea. It's not a red line passage. It's immediately after the red line passage.
Yes. Yes. Since we have it open, the short point in relation to Hill Harmony is the one which your lordship's already made. What it is debating is the distinction between navigational matters and orders as to employment, which is an entirely different inquiry. And if you are looking at that question, as Lord Hobhouse found, acts or omissions which relate to navigation as opposed to employment may occur both before the commencement of the voyage and after the commencement of the voyage. But that helps you not one jot with the correct construction of unseaworthiness in the rules, where that temporal line is drawn very clearly indeed.
In the plain words of Article 3.1.
Yes, yes. And I mean, just to expand on that slightly, we don't attempt to draw any temporal divide by reference to the commencement of the voyage in relation to the obligations under 3.2 and the application of the exceptions in 4.2 to the obligations under 3.2. So the obligations under 3.2 obviously run back in time to the loading of cargo and so forth, and that there may be matters that affect the subsequent prosecution of the voyage that take place even earlier than that. If they don't go to unseaworthiness, then the exceptions may apply regardless of when the act or omission occurred. But if they go to unseaworthiness, then you're simply in a different regime.
It's a Venn diagram, really, and you carve out the seaworthiness
that's
aspect.
exactly right. Isn't it?
Then point 6 that we make is that both mechanical tasks and those requiring the exercise of skill and judgment can cause unseaworthiness. There is no distinction between those two categories of act or omission that is to be found in the authorities. And I've touched on the factual point of detail that it's not the case that there's a distinction to be drawn on the facts anyway between chart updating and passage planning. Both may require an exercise, or do require an exercise of skill and judgment in many cases. And similarly, there's no bright line distinction.
Well, your point is that it matters not whether it requires an exercise of skill and judgment. If, as the judge found, it renders the chart a defective chart, and therefore it renders the ship unseaworthy.
Exactly. If the chart is defective,
Doesn't matter whether it's defective because they failed to do a tracing exercise or because they failed to exercise proper judgment.
no, exactly. And there's a very very important point here, perhaps. Let's suppose maybe it's worth turning it up again. If you've got the supplemental bundle and the notice to mariners at tab 6. Let's suppose that just before the words numerous depths less than charted, so after numeric 2, but before the text, it said in bold, you must write this on the chart. As I understand the owner's case, he would then accept that the vessel was unseaworthy on departure from Jamais, because there had been a failure to update the charts in accordance with the mechanical process required by the notice to mariners.
Or if it said, this must be indicated on the charts, but leaving it to the judgment of the navigating officer as to how to do that.
Yes, yeah, that's a halfway house.
I mean, maybe he would say that, still would say, well, that would never happen.
Yeah.
He may be right about that. I don't know.
But if in the same way as the notice to mariners in the first tab of the second supplemental bundle says amend delete, if this notice to mariners had said amend the chart so that this legend appears at the top, again, as I understand the case that's put against me, it would be accepted that rendered the vessel unseaworthy. The consequence is exactly the same. The consequence is that on departure from Jamais, the vessel has a defective chart sitting on the chart table. And of all the illogical lines to draw, it is supremely illogical to say that the question of liability under Article 3.2, I beg your pardon, 3.1, when there's a defective chart on board on departure from a port, depends on whether a notice to mariners has a mandatory as opposed to a discretionary provision in relation to putting a warning on the chart, which the judge has held, as a matter of fact, should have been on the chart.
judge has made, having heard the evidence, a value judgment, given this notice to mariners, that prudence required a certain mark indication to be made on the chart, and indeed not just prudence, but it was defective as the chart was defective.
The chart was defective as a result, and it was inconceivable. I mean, it's not something that ultimately. I mean, he heard a lot of evidence as to what should be done and what shouldn't be done, whether it was hatching or not hatching and so forth, whether it was on the passage plan or not. But he held, as a matter of fact, that this warning should have been on the chart.
Yeah.
That the chart was defective because it wasn't, and it was inconceivable that a prudent owner would allow the vessel to go to sea as a result.
Given the 10 hazard points that there are underneath 2, you can understand why. Because it was to go outside the channel near anchorage 3, 5, returning it anywhere was very hazardous.
Yes, now, to be absolutely fair, my recollection is that the exercise was done and that none of those 10 points would in fact have been of any relevance.
But the point was, and they're the ones in 6 as well, aren't they, in the notice to mariners?
Yes.
In the very last. But the point really was that what that is, it's really, and it maybe was an exercise of judgment, because what it demonstrated to a prudent seaman was that the charts outside the fairway, the depths outside the fairway were inherently unreliable.
Yes, yes.
And that was the warning that was required to be put on the chart.
Yeah. I mean, the only safe way out of this port for this vessel was to stay in the fairway. So you had to have something that reminded you on the chart that you had to stay in the fairway. And the reason why you had to stay in the fairway was because the chart was unreliable. I mean, it was precisely why the judge, I beg your pardon, the master went out of the fairway, and indeed why his actions in going out of the fairway were defended by Captain White on behalf of the owners. He said, "Well, I thought I'd got enough water because I looked on the chart and I could see deep water."
You rely on the facts themselves. It was the proof in the pudding was that he went outside the fairway when it was because he thought he was safe to do so. But if he'd known this, it would have been mad to go outside the fairway.
Exactly. And you see, Captain White, who was the expert for the owners, when he produced his first report, it seems had overlooked the notice to mariners and thus had overlooked the warning. And one of the reasons why the judge felt that his evidence was undermined.
The judge was quite critical of his evidence because he felt that Captain White had pinned his colours to the non-notice of mariners mast.
Yes.
And couldn't quite bring himself to row back from that. That's how I read it anyway.
Yes, or at least reevaluate. Couldn't properly
reevaluate.
I think it's perhaps a fair way of putting it.
But fortuitously or otherwise, it shows what can happen when it's not on the chart.
Yes. Exactly. It shows you what happens when it's not on the chart, and why. And it actually was crucial to the judge's finding of fact that the warning itself had to be written on the chart, because if you look at on the chart, in a number of places, in rather pale magenta, if you look on the coloured one, there are references to the notice to mariners. So, sorry, I need the coloured one.
References to
Well, there is one
on the chart.
one in the middle of right in the middle of the chart, NM 6274P10.
Yeah, that's right. And so what you do have on the chart is the reference to the notice to mariners, which it seems that Captain White missed when he was preparing his first report. Yeah. And that was a factor in the judge saying it's not enough to have the reference to the notice to mariners. You've actually got to extract the warning itself and put the warning itself on the chart.
Is that a convenient moment, Mr. Ross?
Yes, if I've got to the bottom of my seventh proposition, then perhaps I could. Seven, it covers some of the ground we discussed earlier.
That's the non-delegation.
It's the non-delegability point, and hopefully.
Come to that in the morning. You'll refer us to whichever authorities you want to refer us to.
Yes, Muller, that is a convenient moment. In terms of tomorrow, what I was intending to do was to take your lordships through quite a lot of the authorities that we have set out in your skeleton, which illustrate these propositions.
Yeah.
I'm conscious that I don't want to take up the court's time in going to authorities with which you are familiar to illustrate propositions that in our submission are not particularly contentious.
Well, I think the best thing is if you start showing us the authorities, if between us we think we're sufficiently familiar, we don't need any further assistance, we'll let you know.
I certainly don't want to bang on points that are well within your
It might
lordship's
be
knowledge.
helpful also if overnight Junior could produce just a list of all the references, so we have them in black and white.
Yes. Yes.
Okay. 10:30 tomorrow night.
Likewise.